Have you seen the YouTube clip Leeroy Jenkins? Because we're about to Leeroy Jenkins this. Welcome to IJ's Short Circuit Podcast. I am your guest host, Sheldon Gilbert, President and CEO of the Federalist Society and alum of the Institute for Justice and the Short Circuit Podcast. I am delighted to have the opportunity to be guest hosting this podcast here at University of North Carolina School of Law. UNC School of Law has a special place in my history with the Institute for Justice. It was about 9 years ago that we launched this annual tradition of a Supreme Court preview here at UNC Law that we record live with Short Circuit. And I'm so glad for the opportunity to be back participating with all of you. I am also so glad for those who are listening and can't be here to be wearing my UNC Tar Heels necktie, gifted to me by UNC Law alum Adam Griffin at our second annual Supreme Court term preview here at UNC some many years ago. With us, our panelists today are Justin Pearson from the Institute for Justice. You can Google or ChatGPT his resume. If you use ChatGPT, it'll hallucinate some really exciting facts about him. I'm not going to go into his entire career. He's had a very impressive litigation career. He went to University of Miami Law School and has a lot of really fun cases that I'm sure he's willing to talk with you about. And we'll ask him here in a minute to talk about what he likes most about his career. And of course, we are so delighted to have Dean Andy Hessick as our other panelist. Professor and Dean Hessick has been truly a friend of the Federalist Society for many years and is really one of the people that impresses me with his commitment to the ability to disagree without being disagreeable, the importance of reason and debate and dialogue. And it's something that I've been proud to see him committed to for many years. And I would be remiss if I didn't remark that he is still only the second best Hessick at the University of North Carolina School of Law. Carissa is a wonderful professor and one of my favorite people and has been for many, many years. We're so delighted for both of you to be joining us today. Again, the students can look up your bios, but I would like to start with you, Dean Hessick, telling me a little bit about what your favorite part of your job is. And you've got a little bit of a new job right now.
Yeah, thank you, Sheldon. Thank you. I do have a new job, and my favorite part of the job is easy to say, and that is seeing everything that's happening at the law school. As a professor, you sort of are siloed in, and you know the few things that you're doing, you know what your students are doing, but you don't get to see all the amazing things that are happening. And now as interim dean, I get to see all the incredible things that we're doing, and we're doing just so much between the classes, the clinics, the student groups, things like this today. And I'm proud of the school, and I'm delighted that I get to see it all.
Terrific. Thank you. Justin, tell us a little bit about what you love about your job.
That's a hard question because I have one of the greatest jobs in the world. I get to wake up every day and sue the government. It is a lot of fun. I truly enjoy my work. Not every lawyer can say that. Most can't. I work for the Institute for Justice, which is the nation's largest philosophically libertarian, so just small libertarian, nonpartisan, public interest law firm, and it's just an amazing place to work. We're up to over 180 employees in 6 offices. Our headquarters are up near D.C. in Arlington, Virginia. I run our Miami office, but we all litigate together across the nation. And it's just so cool. You know, we've had 13 U.S. Supreme Court cases. We've won 11 of them. They're cases you've probably studied in law school, like Timms and Granholm and Tennessee Wine and Spirits and Espinoza. I mean, those are all IJ cases. And if you're as interested in constitutional law as I am, well, you're in luck because IJ keeps expanding, and so we have all sorts of opportunities. We have a great summer clerkship program called Dave Kennedy Fellows. That's a paid summer at IJ where you get to work on constitutional issues. We have one-day seminars where IJ will pay your travel expenses to travel to a location to learn from IJ lawyers. We have Bigham Fellowships where if you have a different judicial clerkships lined up and you have a gap year, you can spend that gap year suing the government with me. And if you already are kind of thinking about where you want to practice law after all that, well, we are expanding. We have attorney positions that are opening up because of these expansions at our headquarters, at the Miami office where I work, and most of our other offices as well. If you're interested in any of this, we have QR codes here that you can click on. And for those of you listening at home, you can also find this info at ij.org. But so I guess I'd say my favorite thing after that long-winded answer, Sheldon, is that after seeing the things I've seen, suing the government is very cathartic. It really is.
Justin never lacks enthusiasm for describing what he loves about his job. We are so excited to be here. Again, this is a live recording of IJ's podcast Short Circuit, and today we're going to be doing a preview of the Supreme Court's upcoming October 2025 Supreme Court term, which, as all of you know, starts on the first Monday of October. So we're very close to the beginning of the Supreme Court term, and we want to give you a little bit of flavor for the big issues and cases that are going to be on that term. So let's talk about how this is going to work. First of all, we're going to have a trivia competition between Justin and Dean Hessick during the course of today's discussion. We're going to start with some trivia questions, and then we'll take a little bit of break from the trivia questions, and we'll let Justin and Dean Hessick talk about one merits case on the docket this term that they find particularly interesting and important. We'll then go back and do some more trivia questions, and then each of them will talk about a pending certiorari petition that they think is important and ought to be getting more attention, and then we'll go back to the trivia questions. Okay, so here's how the trivia questions are going to work. Number one, if Justin Pearson wins, Dean Hessick owes Justin Pearson lunch. Okay. Now, Justin already said that if Dean Hessick wins, he might not be able to provide lunch for Dean Hessick because he's jumping on a plane to get the heck out of Dodge. We've discussed this already, and Dean Hessick is ready to seek a TRO to block Justin's plane from taking off. If necessary, we'll make sure that Justin can provide lunch for Dean Hessick. That said, the students also have a chance to steal some of the questions. If our great panelists are unable to provide the correct responses, you'll have a chance to steal. And if the students outperform either of our esteemed panelists during today's event, then what you'll win is an additional social activity at UNC Law School funded by Federalist Society. So we'll see how everybody does. There is one final rule to the trivia game that we have, which is my point scoring system would not survive a challenge under the Administrative Procedure Act because it will be entirely arbitrary and capricious. So we will have one of our students here keeping score. Raise your hand and say loudly your name. Nathaniel is going to be our official scorekeeper. He's going to keep score and tell us who wins at the end of today's recording. All right, let's get started with trivia questions. Why don't we start, Professor Hessick, why don't we start with you?
Sure.
I'm going to read you a haiku about a case that's on the Supreme Court's docket. You need to tell me what that case is. Are you ready?
Yes.
That was not very persuasive. All right. Commish is now out. Was Humphrey's executor wrongly decided? That's your haiku.
I'm going to go with Trump versus, is it Slaughter?
Trump versus Slaughter. That's absolutely right. Trump versus Slaughter. Can you tell us a little bit about what that case is?
It's about whether the president can fire a member of the FTC, and I think that he did, and then he was enjoined, but then the Supreme Court issued a stay of that injunction, I think.
And then has now scheduled the case to be argued
that's
on the
right.
merits
That's
docket.
right. Yeah,
that's right.
that's
Okay, so I'm going to give you 3 pi points for correctly getting that right, but I want to give a bonus question to you. And if you don't get it right, then Justin can steal the question. If Justin doesn't get it right, then we'll throw it out to the students. So it's a Humphrey's executor-related question. Are you ready?
Yeah.
All right. When, and I need the month, when was Mr. Humphreys fired by President FDR?
The month, huh?
Yeah. We don't play games here. Actually, we do. We literally do.
Yeah, we do play games. I'm going to go with November 1934.
That's a good guess, but it's wrong. All right, Justin.
Well, I mean, I think that would be a little too close to when the actual court ruled. I mean, it takes a little while, as I learned at IJ, for the litigation to happen.
It used to take a little while. Sometimes things go up to the court a lot faster.
That's true. Maybe this was one of those cases.
Shadow docket.
I'm going to go a little earlier. I'm going to say February of 1933.
February of 1933, also wrong. All right, we're going to turn this over to the students. Students, do we have any volunteers? We've got a student right here. What's your name?
Jack.
Jack, tell us the month and year that October 1933. Fantastic. You get 1100 bonus points. Write that down. Write it down. All right. And a bonus question for you if you'd like to double it. Double or nothing? Double or nothing. You want to go for it?
Sure.
Do you know the salary of Mr. Humphreys?
Oh, God. Shot in the dark, 10,000.
10,000. You're correct. Double or nothing. All right. Very good. You guys are doing a great job educating your students. I like this. All right. Justin, let's go to you. Let's do another haiku. All right. Okay. I'm going to give you a haiku, and you're going to tell me what the case is. The 10th Circuit says some therapy is conduct, but should it be speech?
Is that, oh God, I might get this one wrong, but is that Childs versus Salazar?
You can't get this one wrong. You do occupational speech cases all the time. Yes, you're correct.
Oh,
you're absolutely correct. Can you talk a little bit about the case?
So, I mean, obviously, it's a controversial subject, and I have nor does I have any opinion on the subject itself. But what I will say is it touches on something that's near and dear towards IJ's work, which is the speech conduct distinction. And the lower court ruled that it was conduct, or at least it was just an incidental restriction on speech, incidental to conduct. It's something that comes up a lot in IJ's work, where oftentimes we'll fight with the government over whether something is speech or conduct. If it's speech, it gets the burden on the government, maybe strict scrutiny, even intermediate scrutiny, the burden's on the government. If it's conduct, it gets the rational basis test, which is highly deferential. Oftentimes, if we win that argument at IJ and the court says it's speech, not conduct, the government will just give in right then. So, oh, you mean we actually have to produce evidence and show that what we're doing actually accomplishes something? And so we'll win. And so we're watching this case because it touches on that, but really what it had to do with, going back to the case itself, is the 10th Circuit ruled that it was conduct, not speech. So they applied the rational basis test, and we'll see whether the court agrees that that's the right test. And, it's not always true, but it's often true that the test may decide the outcome.
Well, you absolutely did get it right, so you get 1 point. I think that's only fair, given that your organization has done a bunch of occupational speech cases, and so it's kind of an unfair advantage. Like, let's be honest here. You should have gotten that one right. Now,
well,
do you think you can
get
the bonus?
Things in life I should have done.
Do you think you can get a bonus question? Can we give you a bonus haiku and see if you can get it right?
Sure, why not?
All right. Okay. Music company sues ISP, re-IP. Which music label?
It's Cox Communications versus Sony.
Sony. So the music label is?
Oh, the music label is Sony.
Very good. Music label is Sony. All right. Fantastic. You can get another point for that.
Wait, how many did Dean Hessick get?
Almost 10.
Yeah. What can I say? I told you that my rules would not survive Administrative Procedure Act challenge.
Just so the record's clear, Sheldon and I used to work together at IJ, so there might be something going on in the background.
There might be just a tinge of revenge going on here. All right, thank you. That's very good. All right, so let's take a pause from our trivia game for a minute, and let's turn it over to both of our panelists to each talk about a merits case that's on the docket this term. Why don't we start with you, Dean Hessick?
Yeah, thanks. So there are a lot of great cases on the docket this term, and I want to talk about Burke versus Choi. And as you'll see as I start talking about it, I thought this would be a great case to talk about, but it's pretty complicated, so just bear with me. Right? So it starts with Harold Burke. He hurt his foot while visiting the Delaware beaches. And he went to the doctor, right, in an emergency room, and but he alleges that the doctor made it worse. And so he sued for malpractice, medical malpractice. Now, he sued in federal court, and but he's alleging a state cause of action. It's a Delaware state action. And so he's got this Delaware claim in federal court. Now, ordinarily, in federal court, all you have to do to start your claim is you file your complaint. Your complaint has to have a short and plain statement establishing the basis for relief. That's Rule 8 on the Rules of Civil Procedure. But here's the thing. Delaware has a rule that requires a plaintiff in a medical malpractice case to get an affidavit, to file an affidavit called an affidavit of merit from a medical professional saying that that your claim has merit, right? And the question is, does this Delaware rule apply in federal court, right? It sounds like a first-year law school exam in Civ Pro, right? I've in fact asked this exact question before. The question, it seems deceptively simple because you're like, well, you just have to pick. Oh, does the affidavit rule apply or not? But it's actually really, really complicated, and it involves the Erie Doctrine. It involves the Rules Decision Act. It involves the scope of delegated power under the Rules Enabling Act, and all sorts of other things along the way, including like the basic question, what's the difference between substance and procedure? So to get a bit more into it, when a federal court hears a state law claim, the basic rule is the federal court applies state substantive law and federal procedural law. So the feds can control their own procedure. For example, the federal court controls what the complaint looks like, can schedule hearings, et cetera, et cetera. And this is the basic Erie Doctrine, right? But it also is codified in a statute called the Rules Decision Act, right? Rules of Decision Act. So most of the procedural rules for federal courts, they're written into the actual sets of rules, like the rules of civil procedure. And those rules are just, they're federal regulations, essentially, and they operate just like laws. And when the federal rules conflict with state rules, the federal rules trump, and they control. Great. There's a lot of setup. See, I'm telling you, it's a complicated case. Okay, great. But here's the first of various catches, and that's the courts, they're the ones who promulgate these rules of procedure. And the reason they can promulgate them is that they've been delegated authority by Congress under something called the Rules Enabling Act. Now, Congress, it has broad power to write procedures, but it has limited the power that it's given to the courts to promulgate these procedures. It says, courts, you can promulgate these procedures, but you can't promulgate procedures that change or modify or limit or expand substantive rights. Right? You can't do that, right? So it limits the scope of permissible rules. Okay, great. So what does this mean, right? What does this mean for the application, the applicability of the Delaware affidavit of merit rule? Well, in the end, it's really going to turn on whether or not the Delaware rule is substantive or procedural, right? And here's why. So we can start by asking, okay, do the rules of civil procedure apply? Because if the rules apply and they conflict with the Delaware rule, the civil rule will just trump, right? Because they're the federal rules. Okay, so we ask, do they conflict? And one could say probably not. There's a decent argument that they don't conflict here. And that's because the rules set forth requirements for the content of a complaint, and they don't really say anything about whether or not you have to have other things that go along with the complaint. There's certainly counter-arguments, but that's sort of my own view. I should add, now that I'm so deep into it, I did represent someone who filed an amicus brief in this case, and so there's that caveat. I should also add, now that I'm on this, I am dean of the law school right now, but I am definitely speaking as just myself. Please, nothing I say is reflecting views of the university or of the law school.
He's new to this job. He forgot to do the disclaimer at the beginning.
Yeah. I got it though.
Yeah,
it's close enough. Okay, but that's right. So if there is no conflict, right, then under the rules, we'd be like under the Rules Decision Act. Sorry, we'd say, okay, there's no conflict. Then we just have to ask whether the Delaware law is substantive or procedural. And if it's procedural, you don't have to apply it. And if it's substantive, you do have to apply it. Okay, great. Now, what if there is a conflict between the federal rules and the Delaware law? Well, then one would say, okay, you apply the federal rule. But remember, the Rules Enabling Act says that the federal rules can't modify or limit, expand a substantive right. So again, we're going to have to ask, is the Delaware rule substantive? Because if it's procedural, it's fine if there's a conflict for the federal rules to displace the Delaware rule. But if the Delaware rule is substantive, the federal rules, they might not be able to limit that Delaware substantive right. So no matter how we come at it, we really should ask the question, is the Delaware rule substantive or procedural? So after all of that, we get down to this last question, is it actually substantive? I think there's actually a decent argument that it is substantive. Obviously, the parties disagree about this. But in my view, I think that there's a pretty good argument because it does limit the availability of recovery in actions for medical malpractice. And so it seems like it's meant to constrain your ability to recover. So in these merits cases, I sometimes like to make predictions. I lean towards them saying that the Delaware rule applies here. I totally recognize that I might be wrong because Erie questions are super complicated, but that's where I land.
Well, that's really interesting. We don't get very many Erie cases these days. It's kind of few and far between for the Supreme Court to clarify the Erie doctrine. The Erie doctrine, I'm sure, looms large for everyone in this room in law school. It's one of those cases that you hear about and read about and study about, and it kind of sticks in your mind in your civil procedure class. And hopefully, Justin remembers that civil procedure class because we're going to give him a trivia question about the Erie case.
Oh, jeez.
All right. But this is your chance to catch up.
Okay.
You might be able to catch up.
All right.
You know what's on the line here? 1100 points. All right? You ready?
Wait, what do you say 1100? Talking about 1,100 points?
Well, I didn't say that. This is in binary. So they get 1,100 points, actually 2,200 points. Your points are available only in binary. So for anybody who can do the math and convert decimal to binary, or binary to decimal, 1100, what number is that in binary? It's 12. But look, that's a lot better than what you're doing right now. So you could catch up.
All right, fair enough.
So
Let's go.
let's give you some Erie questions. Question number one. So the fact pattern in Erie involves a gentleman named Tompkins who lost an arm, allegedly because it was hit by an unsecured refrigerator door as it was speeding by him. Which arm did he lose?
Jeez.
He got a 50-50 chance.
I'll go with his left.
I'm sorry.
Can I
You're wrong.
steal?
But you know what? This means Dean Hessick gets to steal.
I'm gonna go with right.
Oh, that's 12 more points to Dean Hessick. But I want our official quiz scorekeeper to make sure to record it in binary. All right.
See, I figured he'd be walking in the same direction as the train. If he was walking in the other direction, he should have seen the train coming.
Well, that actually gets to a really interesting question. So there's a remarkable law review article by a professor named Brian Fry from 2018. And Brian was interested in this question of whether or not the facts, as you see in the Supreme Court opinion, are the facts of what actually happened. And he does this kind of deep dive into the record of the case. And he makes an argument in his article, The Ballad of Harry Tompkins, that in fact, it's not true that this is how he was injured. That from the perspective of Professor Fry, he believes that it's much more likely that at 2 a.m. when he was hit by the train, and that's going to be a bonus question here, which train was it? We're going to see. You're going to lose points if you get it wrong, though, Justin. I just want you to know that. Brian Fry argues that it's much more likely, based on the factual record, that in fact Mr. Tompkins was trying to break the law and jump onto the moving train along with a couple friends and was injured and fell off as he was trying to illegally board the train. And that's the real story of what happened.
That fact pattern led him to have his arm severed?
Yeah, so he missed jumping on the train, and the arm falls under the tracks and severs the tracks. It severs the arm.
I have a lot of respect for Professor Fry, so he's probably right.
It's a really interesting article. You should all go check it out. And it has a lot of really useful trivia that Justin will absolutely get wrong about this case. So you will lose 1,100 points if you get this question wrong.
Delightful.
Which train injured Harry Tompkins? What was the name and number of the train that injured Harry Tompkins?
Well, wait, what? All right, well, based on the case style, I'm going to say it's the Erie Railroad.
It's the Erie Railroad, but trains have names. And they have numbers. Justin,
I mean,
surely you remember this from law school.
I do not.
All right, you know what? We just had a great Erie answer from Dean Hessick.
So can I make a guess?
You can make a guess. Go ahead.
I mean,
You're going to lose a point for it, though.
if I don't make a guess, do I still lose a point?
Yes, you will still.
All right, then I'm going to go Thomas the Train.
Oh, no.
And number.
To quote Billy Madison, I award you no points.
And wait, hold on, I'm not done. And out of respect for a constitutional amendment that is definitely not an ink blot, I'm going to go with number 9.
that is still wrong. All right, I'm going to throw it out to the students. You can redeem yourself with a correct answer here. Does anybody know what the train was that injured Mr. Tompkins? Anybody? Any answers? I might turn it. Yes. Do we have an answer? Can you say your name very loudly?
My name is Caroline.
Caroline?
Ashley Special, $24.99.
The Ashley Special, $24.99. Obviously the correct answer. And you just did better than a practicing attorney who graduated from law school in, 2002?
That is, wow, you're right.
Yeah, so I think you guys get 2,002 points. There we go. All right. Let's get back to our merits cases. All right, we just had a merits case from Dean Hessick. Justin, it's your turn to tell us about an important merits case on the docket this term.
Sure, and I actually appreciate Dean Hessick's presentation for many reasons, but one is that it touched on one of my pet peeves, which is this phenomenon of people being locked out of the courthouse, of not getting their day in court. I think there are too many obstacles to getting into court. And my case touches on that as well. It's Olivier versus City of Brandon, Mississippi. And basically what happened there is Mr. Olivier is a devout Christian who thinks that his duty is to be evangelical and to go and basically be what could loosely be described as a sidewalk preacher. And he goes and shares his views on religion with people and tries to, influence them. In Brandon, Mississippi, they have an amphitheater, and they have a so-called protest zone. If any of you are familiar with free speech zones, I mean, just the fact that they exist, shows that there's a problem going on elsewhere. But they're typically far away from where anyone could actually hear what you're saying, and that's true in this case as well. The protest zone was nowhere near where anyone else actually was. So Mr. Olivier, first of all, he wasn't protesting anything; he was just sharing his religious views. But second of all, he wanted to be where people could actually hear what he was saying, and so he gets cited for violating this ordinance and as people often do, he doesn't have the time or the resources to fight it. So he pleads no contest. He pays the fine. He moves on with his life. But then he realizes, he wants to keep doing this. And he realizes that this is probably a First Amendment violation. So with the help of the First Liberty Institute, he brings a First Amendment challenge that's forward-looking. He's not trying to undo the no contest citation. He's not trying to get his money back. He's planning to speak more in the future. He believes that speech is going to be censored, and he does something that happens often in First Amendment cases where he seeks prospective relief, saying that he should be allowed to do this thing under the First Amendment. It's very, very common. And so he goes to court, And the attorney for the town, argues that his case was barred by something called the Heck bar, which I'll explain. I'd be very impressed if any of the law students were familiar with the Heck bar. It deals with a narrow situation that I don't think applies here. But basically what happened with Heck, it's a case called Heck versus Humphrey in 1994. There was a convict, someone in jail, in prison, who, he had a trial, he had been convicted. While he was in prison, he brought a backward-looking claim for damages for wrongful imprisonment, basically trying to get another bite at the apple to relitigate the case that he lost when he got sent to jail. And the Supreme Court says, no, you can't do that. Like, if you're imprisoned for something and you lost that case to send you to prison, like, you can't then bring a backward-looking damages case to try to, undermine that conviction. Well, that clearly doesn't apply here, right? Mr. Olivier, for whatever you think about what he wants to spend his time doing, he was seeking forward-looking relief. He wasn't trying to get his money back. He wasn't trying to undo anything. He wasn't doing anything backward-looking at all. First Amendment violations are irreparable harm the second you're censored. And so what he was doing was not unusual in terms of his legal strategy. But the district court rules that his First Amendment claim is barred by this Heck precedent. They're not going to rule on the First Amendment claim. So then he goes up to the Fifth Circuit, and the panel there affirms. It agrees and says, no. And honestly, I can tell you, it seems like he probably would have had a pretty good chance to win on the First Amendment argument if the court would reach it. But the panel at the Fifth Circuit agrees with the district court that his claim is barred by Heck because he paid this fine. That triggers Heck somehow, even though he's not trying to get his money back. And so then his counsel wisely moves for en banc review. Who here knows what en banc review means? Yeah, gentlemen. Yeah.
It's the full circuit. They hear the case.
That's right. It's the full circuit. So instead of the 3-judge panel, it's all of the judges on the Fifth Circuit. And they move for en banc review, and they come up 1 vote short. 8 of the judges on the Fifth Circuit would have granted en banc review. 9 would not. And there are 3 very, what we call zealous dissents, pointing out that this is creating a circuit split with other circuits, that this is clearly not what that really narrow precedent in Heck was designed to do. Basically writing dissents in a way that should get the court's attention. Now, as we may talk about in a minute, cert petitions are rarely granted. But one of the things that, at least in theory, is supposed to get the court's attention is when there's a circuit split. And so the dissent from the denial of en banc review made sure to point out that this is creating a circuit split. And so now this petition has been granted. IJ, not myself personally, but my colleagues at IJ have filed an amicus brief in support of the petitioner, laying out several reasons why the petitioner should have been allowed to have his First Amendment claim heard. So if you're interested in this, please read IJ's amicus brief. There are lots of places you can find it, including our website, again, ij.org. To make a long story short, this is clearly not what happened in Heck, right? Heck was about someone in jail trying to kind of undermine their conviction by suing for backward-looking damages. This is a guy who wants to speak in the future and is seeking prospective relief to do so. Hopefully the Supreme Court will do the right thing because there are already too many locks on the courthouse doors. We don't need another one.
Well, thank you. Very interesting. The docket this term has so many interesting cases. And I want to use our trivia questions as a chance to kind of flag some of these other cases that are important and on the docket this term. So with that, why don't we turn to a trivia question and see if we can get you back on the board. Justin, I think you're well in the negative. But first, I'm going to give you a haiku that if you figure out the answer to that haiku, it doesn't give you the answer, but it gets you closer to figuring out the case that we're talking about. All right. So this is a multi-layered question, but it could bring you back. All right. So here's the haiku.
This is the best game ever.
I'm glad you're having fun.
Let the record reflect, in case the microphone didn't capture it, that Dean Hessick said, and I quote, "This is the best game ever." All right.
Agree to disagree.
So here's your haiku. Brown v. Board is like Citizens United and Roe v. Wade. But how? I'm going to read it to you again to see if you can figure out what unites all of these cases and a certain case that's on the docket this term.
Wait, weren't they all cited in one of the briefs or something? I think I actually know what you're going for here.
I really don't think you do.
Oh, all right.
All right, let's try again. Brown v. Board is like Citizens United and Roe v. Wade, but how? What is something that ties all those cases together?
All right.
I'll give you your first clue. It's something that doesn't happen very often at the court. But in these three very high-profile cases, it happened with each one of those
Did
cases.
they skip the Court of Appeals?
No, that's not what unifies these cases.
All right, I'm not going to get this one.
All right. Justin, not very many people know this trivia, so I'm actually going to let you off the hook and just give you 0 points.
Fair enough.
You're not losing points on this one. But Dean Hessick, any theories about what unites these cases and one of the cases on the docket this term, one of the most high-profile cases on the docket this term?
No clue.
Do any students have any ideas? What is unite? Yes. Can you say your name? Sam, what do you think connects these cases together?
Weren't all three of those cases argued?
Oh my gosh, you have great students here. That is absolutely right. It's very unusual that the Supreme Court will schedule a case for merits oral argument, hear the argument in one term, and then say, you know what, we want to re-argue the case the next term. It doesn't happen very often, but it did happen in all three of these cases. And it happened with a case on the docket this term. So first, you need the points for that. And I think we're going to do it in Roman numerals. MCM. Whatever that is, that's how many points you get.
I
All right.
Follow-up question, right?
Go ahead, Justin. Let's give you the...
Calais versus Louisiana.
That is not, in fact, my follow-up question. So minus MCM points. But you are right that is the case, but that's not the follow-up question. The follow-up question is how did Chief Justice Roberts, at the beginning of oral argument last term in this case, which was set for re-argument for this term, how did he pronounce the name of both the parties in the case?
Calais?
That is incorrect. We're going to give this one to Dean Hessick. Oh, the students. Let's see if the we'll give you a try. How did Chief Justice Roberts pronounce the case?
Calais?
That's close. That's close, but not quite right. Do we have any students who want to give this a shot? How did Chief Justice Roberts pronounce this case? All right. Can we have you say your name? Sam. Sam's coming back for more. Sam, how did Chief Justice Roberts pronounce the case? Calais. Calais, not Calais. 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 I have no clue if he pronounced it correctly, but that is, in fact, how the Chief Justice pronounced it. And I wish you had any points that you could give to the students at this point, Justin. But you were so in the hole. So what we're going to do is take the amount that you're in the hole, and we're going to give it to the students. So
That's fine.
we'll have our scorekeeper figure that out at the end of the game.
I'm still doing better than my arguments with my wife.
But at this point, we want to go back to our main programming, and we want to give each of you a chance to talk about a pending certiorari petition that you think is important and ought to get more attention. So, Justin, why don't we let you go first?
Sure, and because I work at IJ, I can't resist talking about an IJ cert petition. I mean, I could talk. Here's what's going on. The government is trying to take our client's $95,000 Cessna because the owner of the plane had a passenger with a six-pack of Budweiser. Now, I could end right there, but I have a few more minutes, so I might as well give you some more details. Alaska has a state law saying that towns are allowed to make themselves dry towns, and that if they do that and someone violates those ordinances, it's an actual crime under state law. As many of you may know, in rural Alaska, they don't have a lot of roads, and so people often fly small planes like Cessnas just to even do things like grocery shopping. And so our client, oh, by the way, I should tell you that the name of the case is Jalpi versus Alaska. Our client, Ken Jalpi, that's how he made a living. Is he had a $95,000 Cessna, and he would fly people around. And he flew someone into a dry town, and it was her husband's birthday, so she wanted to bring him some Budweiser. She had a little bit more than a six-pack, but apparently there was a six-pack that should have been visible to him. And so he gets busted. Ken actually spent 3 days in jail and was fined $1,500 for flying someone into a dry town who possessed a six-pack of Budweiser that, in theory, he should have seen. This then led to a situation where, of course, the government wasn't satisfied. They wanted his plane for themselves. And so this is, oftentimes IJ does things in regarding civil forfeiture. This is criminal forfeiture because he was convicted of flying someone with a six-pack of beer. And so he's been fighting now for 13 years over whether he should get to keep his $95,000 plane. Most of that time, we didn't represent him. We only got involved relatively recently, which is a big problem with these forfeitures, that the math just doesn't add up, and the government knows this, so they just try to wait you out until you give up. But, Ken's a principled guy, and he was mad at what happened. And then before now, it went up to the Alaska Supreme Court, which ended up on the wrong side of a circuit split. So IJ won a case a few years ago, some of you might have studied, called Timms versus Indiana, having to do with incorporating the excessive fines clause of the Eighth Amendment. Since then, most courts, both the federal appellate courts and state Supreme Courts, have correctly viewed the test under Timms as being something where you look at the specific culpability of the person to help determine whether the fine is excessive. The Alaskan Supreme Court went with the minority side of the split, what I view as the wrong side of the split, and said it's more of a general abstract view of the law being challenged. And so they upheld the forfeiture of this plane over this six-pack of beer. IJ has filed a cert petition. And frankly, listen, the court should take it because there's a circuit split. Like, that's one of the big things the court is supposed to look at. And so I hope they do. But also, it touches on another issue that I think doesn't get enough attention, which is that these things are happening every day, but most people aren't willing to fight for 13 years like Ken has. The average forfeiture is $1,200. Many forfeitures are far less than that. Like, not all law enforcement agents, but a lot of them are basically just shaking people down for pocket change, knowing that the cost to fight to get your money back is more than what was taken from you. And so I hope that the court takes this case not just to resolve the circuit split, but also to give some help to all the people across the nation whose rights are being violated every day by having money seized like this and forfeited like this. Thank you.
All right, so we've got our cert petition pitch by Justin Pearson, and now let's go to Dean Hessick for his cert petition to watch.
Yeah, thank you. So my cert petition pitch, it's a cert petition that has been filed by the Supreme Court Clinic, the Supreme Court program here at Carolina Law, and it's called Leeroy versus Georgia. And it has to do with something that that we all could very well deal with any given day. So, right before Christmas, 2020, Miss Anyane is driving along, and she gets pulled over for sort of, drifting in her lane, misusing her high beams, whatever it is. It's easy to pull people over. We all violate the traffic laws all the time. She gets pulled over. The officer comes up, and he says he suspects that she's been drinking, and so he asks to do a blood draw. Right? He has to do a blood draw. And so that's where the legal issues start. So Georgia, this happens in Georgia. Georgia, like all the other states, has a law that says if you drive in our state, then you implicitly consent to a blood draw. Right? Just the mere fact of driving is consent. And that's a big deal because ordinarily to get a blood draw, the cops need to get a warrant, right? They can't just draw your blood, right? But they say we don't need a warrant because you've implicitly consented to the blood draw by driving in the state. And if you refuse, right, after this consent's given, if you refuse, then there are consequences, right? In Georgia, there are two consequences. These are pretty standard. One of them is your license is suspended, right? And what that means is really you can't drive in Georgia. But this applies to anyone who's driving from elsewhere, right? This isn't about you getting a license in Georgia. This is about driving in Georgia. So you're not allowed to drive in Georgia if you refuse. And your refusal can be admitted as evidence in your criminal case if you are charged with driving while intoxicated, right? Now, this raises two constitutional issues, Fourth Amendment issues. So the first one's like sort of Fourth Amendment adjacent. And that first one is something called the doctrine of unconstitutional conditions, right? Is this a valid way to be able to do a blood draw? So under this unconstitutional conditions doctrine, the government can't condition a benefit on your waiving a constitutional right, right? So the government can't say, for example, you get to use the mail and send letters only if you give up some constitutional right, like your right to free speech, right? So the blood draw, right? This runs into that problem. The Fourth Amendment protects against warrantless blood draws, but the state says, "Oh no, we're allowed to. You've consented to the blood draw, and you are allowed to drive in the state only because you've waived that right, not to be subject to the blood draw. Right? That's how your consent comes about." And if you reassert that right, if you reassert your right against a blood draw, you can no longer drive there, right? That seems a pretty straight up and down unconstitutional condition, right? So that's one problem with it. But it's not the only way of thinking about it, because we could also say, imagine it's not a waiver of your right. Because the Fourth Amendment's weird because we say that consent can be a basis for a search under the Fourth Amendment sometimes. So we say, oh, your consent's not you waiving away your right. It's just you sort of giving permission for them to do a search, right? So instead of saying you've waived your Fourth Amendment right, it's more like the officers are not allowed to do a warrantless blood draw because it's unreasonable, but if you consent, that becomes reasonable, right? Because the Fourth Amendment protects against reasonable searches and seizures. That's fine, but consent, for it to be valid, has to be voluntary, right? It can't be coerced. And there's a real question. You're driving along, you get pulled over, the cop's like, you have to agree to this blood draw. And if you don't, I'm sorry, you've lost your license. Is that voluntary for you to consent to it at that point? And also, if you don't consent, this is going to be evidence against you in a criminal case. So even if you haven't been drinking, we're going to have good evidence that you have been drinking. And so you better consent, right? So that is the sort of the issues in the case. The Georgia Supreme Court said, "Oh yeah, those arguments are nice. We reject them," and so that's why UNC has filed a cert petition. Now, I'll also raise a point. Justin said earlier that circuit splits are a really good way to attract the court's attention for certiorari. The problem in this case, and I fully recognize this, is that there isn't much of a split, and that's because in an earlier case in dicta, the Supreme Court did say that, we think that these kinds of things are okay, right? But it was just dicta, and because of it, though, lots and lots and lots of courts are like, it must be okay. And by the way, all 50 states have these laws, like if everyone's doing it, it must be fine. But that doesn't mean that it's fine. And since the issue comes up all the time, right, and it can happen to any of us at any time, it seems awfully important and warranting the court's attention.
Thank you, Dean Hessick. Really interesting. Lots of very interesting cert petitions on the docket this term. Lots of interesting merits cases. Really appreciate your willingness to join the students and talk about the Supreme Court's upcoming term. All right, we're about to close out. There's time, Justin, for you to completely redeem yourself with one last trivia question. Timms versus Indiana was a case, as you said, that was argued by your organization, Institute for Justice. So I'm going to give you a softball.
Oh, boy.
About Timms versus Indiana. And if you get it right, the citation for Timms is 586 U.S. 146, 2019. Our points keeper will multiply each of those numbers together and give you all those points if you get just this one question right about your organization's own case.
Good luck.
Does that sound fair? All right.
Sure.
The day of the Supreme Court argument in Timms versus Indiana, after the argument, the Institute for Justice team walked out of the Supreme Court building, and Wesley, who argued the case for IJ, saw a bird in the sky. And he took it as an omen that he would win in his case. What was the bird that flew over the Supreme Court building at the end of the Timms versus Indiana case?
So before I answer this, I want to point out that Wesley happens to be, and I forget the name of it, but he has to be like a bird watcher.
A birder,
Right.
as we call ourselves.
I think there's some, oh, you one too?
Justin.
Well, unfortunately, I am not. I know maybe 5 birds. So
Pick one of them.
I'm gonna go with a dove.
A dove. A dove. All right. I'm sorry you had a chance. You had a chance. Now, I'm sorry that's not the correct answer.
It was not a dove.
Wesley's going to be so disappointed. Now,
Wesley knows that I don't share his hobby.
but Dean Hessick does have a chance to steal, and it's going to be really embarrassing if Dean Hessick knows this about an IJ case and you didn't. So, Dean Hessick.
I actually do happen to know this. It was a red-tailed hawk.
That's right. It was a red-tailed hawk.
Yeah.
Now, you're not going to get the point. Those points were to redeem himself, but I will give you a point
Sure.
for knowing that, and I
Sure.
think that's only fair. All right, let's go to our scorekeeper. Give us a rough estimate. Did Justin win?
No, unfortunately, Justin did not win.
Absolutely not. All right. Did Dean Hessick win?
He was in the positive.
He was in the positive.
Did not win.
He did great. Who won?
Well, the students did manage to get 8,000.
All right. Can we have a round of applause for the students? Thanks to the students. Thanks to UNC Law for hosting us. Thanks to Dean Hessick. Thanks to Justin Pearson. And this is the end of this live recording of Short Circuit. All right.
Thank you.